She was 10 years old. She had no law degree, no badge, no right to be standing at that table. But in 9 minutes, she was going to do what a team of lawyers couldn't do in 15 years. Grace Mitchell stood at a small wooden table in a county courthouse in rural Oklahoma, her hands folded the way her grandmother had taught her, while a judge who had already spent an entire morning listening to legal arguments finally turned her full attention to a child who was not supposed to matter in that room at all. 3 years earlier, that same child had been pulled away from her mother's hand by a deputy, screaming a name nobody in that courthouse had bothered to write down. Today, she was the reason the room had gone completely silent. What almost nobody watching that morning understood was how the story had actually started, because the ending is never the part that explains anything. It started with a woman named Sarah Mitchell, sentenced to 15 years in prison for a crime that, on paper, sounded almost impossible to picture. She hadn't raised a hand against her own child. She hadn't caused a single one of the injuries the state would spend 4 days describing to a jury. Her crime, according to the prosecution, was quieter than that and far harder to see from the outside. She had failed to stop it in time, and for that failure, a courtroom decided she deserved to lose the next 15 years of her life, without ever once asking the one witness who actually knew what those final minutes had looked like. That witness was 7 years old on the day her mother was sentenced, too young to testify, too young to be trusted, at least according to the attorney who made that call on her behalf. She sat in the second row of that courtroom in a dress her grandmother had ironed twice that morning, gripping her mother's hand so tightly her knuckles turned white, until a deputy gently pried her fingers loose and led her mother out through a side door. The little girl in that second row did not understand, not fully, what 15 years meant. She understood only that the woman who tucked her in every night was being taken somewhere she could not follow, and that nobody in that room seemed interested in what she had to say about any of it. Nobody in that courthouse that day could have predicted that the same child would return 3 years later, not as a spectator in the gallery, but as the person whose single question would finally force the state to answer for everything it had failed to ask the first time around. It would take a grandmother's stubbornness, a law student who almost didn't open the file, an attorney who had spent 15 years chasing cases exactly like this one, and a girl who never stopped believing her own memory even when every adult around her had already decided the matter was closed. Before we dive deeper, let us know in the comments where you're watching from. We'd love to hear from you, and don't forget to hit that subscribe button so you never miss any of our upcoming videos. By the end of this story, you will understand exactly what that 10-year-old asked in an appeals hearing that almost nobody expected to change anything. Before a single letter was ever written to a legal aid clinic 2 hours away, there was simply a town, the kind of place where a scandal never stays inside a courthouse file. It travels through the grocery store line and the school pickup line, through every conversation that stops a half-second too late when the person it concerns happens to walk by. That town knew Sarah Mitchell long before it ever knew her as a defendant. It knew her as a waitress at the diner off Highway 9, as a woman who worked double shifts so her daughter could have new shoes every September, as somebody's neighbor who always waved first, the kind of small, ordinary kindness that later made it almost impossible for people to reconcile the woman they thought they knew with the version described in a courtroom. Sarah had grown up in that same town, the daughter of a mechanic and a school cafeteria worker, one of 4 children in a house that was loud, loving, and never quite had enough money to go around. She left briefly after high school, chasing a job 2 states away that fell apart within a year, and came home not defeated so much as recalibrated, the way people from small towns often do, understanding for the first time exactly how much that town had actually shaped her. She met Grace's father not long after, a relationship that ended quietly before Grace turned 2, leaving Sarah to raise her daughter largely on her own, picking up extra shifts, leaning on her own mother for childcare, building a small, steady life that felt, for a while, like something she had actually managed to construct herself. Dale Coburn arrived in that life almost by accident, introduced through a mutual coworker at the diner, charming in the specific way that people later struggled to describe honestly, because charm always sounds foolish once you know how the story ends. He fixed the leaking faucet in Sarah's kitchen the first week he visited. He picked up extra shifts of his own when her hours got cut one winter. He was, by every outward measure the town could see, exactly the kind of steady, capable man a struggling single mother was supposed to feel grateful to have found. It would take Sarah years to admit, even to herself, that the version of Dale the town saw and the version that existed behind a closed bedroom door were two entirely different men, and that admitting it out loud might cost her the only stability she believed she had left. Grace was 5 when the first small warning signs appeared, the kind of details a child notices without yet having the words to explain them. A raised voice through a bathroom door late at night, a day in the middle of July when her mother wore long sleeves despite the heat, a night when Dale's temper turned on Grace herself over something as small as a spilled glass of milk, and Sarah stepped between them so quickly that the memory would stay lodged in Grace's mind for the rest of her life, sharper somehow than almost anything else from that entire childhood. Sarah told herself, that night and many nights after, that it had been a single bad evening, a rare loss of temper brought on by exhaustion and money troubles, rather than anything more permanent. By the time Grace turned 6, the pattern had become something Sarah could no longer explain away with exhaustion or bad luck. She began keeping Grace closer, inventing small reasons to bring her along on errands rather than leave her home alone with Dale, quietly asking a coworker at the diner whether she knew of anywhere cheap to rent 2 towns over. She was, in her own halting and frightened way, already trying to build an exit, gathering the small pieces of a plan the way people do when they are afraid to say the plan out loud, even to themselves, in case saying it makes the danger they're naming feel more real than they can currently manage. What she did not yet understand was how little time she actually had left to finish building that exit before everything came apart at once. There were, in the months before the incident, at least 2 other nights that would later surface in police reports and neighbor statements. Nights the town would learn about only after the fact, when a case file finally forced people to remember details they had spent months trying not to notice. A neighbor recalled raised voices from the Mitchell house on a Thursday in early spring. Another remembered seeing Sarah at the grocery store the following morning with a bruise along her jaw that she explained, unconvincingly, as a fall in the driveway. None of these details reached the sheriff's department before the night everything finally broke apart. Not because anyone was hiding them deliberately, but because small towns are often better at noticing trouble than they are at reporting it. A gap that would matter enormously once the case reached trial. The night it happened started the way so many of the worst nights do, with nothing unusual at all. Sarah worked a double shift and came home just after 10 to find the house quiet, Dale in front of the television, Grace supposedly already asleep down the hall. It was only later, once the case had worked its way through police reports and courtroom testimony, that the full timeline of that night would be pieced together, and even then, it would be pieced together badly, full of gaps that nobody in the original investigation seemed particularly interested in closing. What is known, what Sarah never once tried to hide once the police finally arrived, is that she made the call herself. She dialed for help before anyone forced her to, standing in her own kitchen with her hands shaking so badly the dispatcher had to ask her twice to repeat the address. The words coming out of Sarah's mouth in that first minute of the call, later transcribed word for word in the case file, did not sound like the words of someone protecting a secret. They sounded, to anyone who actually listened to the recording rather than simply reading a summary of it, like the words of someone finally letting one go, a woman describing exactly what had happened in short, urgent sentences, asking repeatedly how quickly someone could get there. It was this call, more than almost any other piece of evidence in the entire case, that Grace would return to years later as proof of something the original trial had somehow managed to overlook entirely, that her mother had not stayed silent that night. She had been the one to break the silence herself. The responding officers arrived to a scene that would be described in a dozen different ways over the following months, in police reports, in newspaper columns, in a trial transcript Grace would eventually read so many times the pages softened at the edges. Dale was arrested that night, taken from the house in handcuffs while Sarah stood on the porch with Grace pressed against her side. Sarah was not arrested that night, though she would spend the following weeks slowly watching the direction of the investigation shift, almost imperceptibly at first, away from the man who had actually caused the harm and toward the woman who had called it in. It is one of the strange, quiet cruelties that shows up again and again in cases like this one, that the parent who stays and calls for help is so often easier for a prosecutor to build a case against than the parent who leaves and disappears, simply because the one who stayed is the one still standing in the room when the hardest questions start. Dale Coburn was offered a plea deal within months of his arrest, a deal his own attorney would later admit. Off the record, he hadn't expected the state to offer so readily given the severity of what he was accused of. He took it without hesitation. In exchange for a guilty plea to a reduced charge, he received a sentence that would keep him behind bars for far less time than Sarah was about to be handed for failing to stop him, a detail the local newspaper mentioned in a single sentence buried near the bottom of its coverage of the case. Easy to miss unless you already knew to look for it. It was a detail that would haunt Grace more than almost anything else in the years that followed, the quiet unfairness of watching the man who caused the harm receive less time than the woman who tried, however imperfectly, to end it. Sarah's case went to trial instead of ending in a plea deal, represented by a court-appointed attorney named Warren Doyle, a decent man by most accounts, patient with his clients and generally well-regarded around the courthouse, but one carrying a caseload so heavy that Sarah's file was one of nearly 90 he was actively managing that same year. It is difficult to build a strong defense for any single client when 90 other files are competing for the same limited hours. And it would take years before Grace fully understood exactly how thin her mother's defense had actually been. Not because Warren Doyle didn't care, but because the system he worked inside never gave him enough time to care as thoroughly as the case actually required. The trial itself lasted 4 days, a fact that still strikes anyone who examines it closely. How little time it takes for a courtroom to decide the next 15 years of somebody's life. The prosecution built its case around a single, powerful idea, simple enough for any jury to grasp within minutes. A mother is supposed to protect her child, and if she fails to do so, the law is entitled to hold her responsible, regardless of what fear, confusion, or danger she herself might have been living inside at the time. It is not an unreasonable idea on its surface, and it is in fact the exact principle that keeps children safer in countless homes across the country. But applied without nuance, without asking a single question about what a frightened woman in an abusive relationship actually understood about her own options in the moment, it can just as easily crush someone who was, in her own limited and terrified way, already trying to get out. Sarah's attorney called only 2 witnesses in her defense across those 4 days. He did not call a single expert on domestic violence or coercive control, a type of testimony that had, by that point, already begun reshaping similar cases in courtrooms elsewhere in the country. He did not call the coworker from the diner who could have testified about the apartment Sarah had been quietly inquiring about in the weeks before the incident, a detail that might have shown the jury a woman already in motion toward leaving, rather than a woman who had simply stayed and done nothing. And he did not, in the decision that would come to matter more than any other, call 7-year-old Grace Mitchell to testify at all, on the grounds that a child that young could not be relied upon to accurately recall the events of that night, a judgment call that seemed reasonable to nearly everyone in that courtroom at the time. The jury deliberated for just under 6 hours. When they returned, they found Sarah Mitchell guilty of felony child endangerment, a verdict the judge would describe from the bench as necessary to send a clear message about parental responsibility to the wider community. The sentence that followed, 15 years, drew a small, audible gasp from the gallery, not because it was unprecedented for this type of charge, but because everyone in that room understood, in the particular silent way small towns understand things without saying them aloud, that Dale Coburn would very likely be a free man again, long before Sarah ever was. Sarah was led out through a side door that afternoon, and the last thing she saw before the door closed behind her was her 7-year-old daughter reaching for her hand, held back gently by a deputy who was simply doing the job he had been assigned that day. For the first several months after the sentencing, Grace lived with an aunt who tried her best but had 3 children of her own, and very little patience left over by the end of most days, an arrangement everyone involved understood was temporary from the start. She was soon moved to her grandmother's small house on the edge of town, a quieter, gentler arrangement, though one shadowed constantly by the unspoken weight of what everyone in that community had already decided to believe about her mother. Grace, still only 7, grew up almost overnight in those first months, fielding questions from classmates who had heard some version of the story from a parent at the dinner table, questions that were rarely cruel on purpose but landed cruelly all the same, questions she learned quickly to answer in short, flat sentences that gave nothing away. Her grandmother's house became, in those early months, the only place Grace felt she didn't have to perform composure for anyone. It was a modest, three-bedroom home with a porch swing that had belonged to Grace's great-grandmother, a kitchen that always smelled faintly of coffee, and a spare room that Grace's grandmother converted into a bedroom within the first week, hanging curtains she had sewn herself from fabric left over from another project entirely. It was in that room, late at night, that Grace first began writing down things she remembered, not because anyone told her to, but because she was terrified of forgetting details that felt, even at 7, like they mattered more than the adults around her seemed to think they did. It was her grandmother, in the end, who first noticed that Grace was not simply grieving her mother's absence the way other children in her position might. She was studying it, methodically, the way some children study a subject at school that has captured their full attention without anyone quite understanding why. Barely 8 years old, Grace began asking her grandmother pointed, specific questions about the trial, questions that went well beyond a child's usual curiosity about a missing parent. Why had Dale gotten less time than her mother? Why had nobody ever asked her what she remembered from that night? Why did the newspaper article her grandmother kept folded in a kitchen drawer describe her mother as having failed to protect her, when Grace's own memory of that night included her mother's voice, sharp and unafraid, telling Dale to get away from her before the police were ever called at all? Her grandmother, worried at first that Grace was fixating on something no 8-year-old should have to carry, tried gently redirecting her attention for a while, suggesting activities, encouraging friendships, hoping the intensity of the questions would fade the way childhood obsessions often do. When it became clear the questions were not fading, that if anything, they were growing sharper and more specific with each passing month, her grandmother made a decision that would quietly change the entire trajectory of the case. She reached out to a legal aid clinic 2 hours away, a small operation run out of a university law school, staffed largely by students and a handful of supervising attorneys who took on cases the rest of the legal system had already closed the book on. Cases too old, too poor, or too complicated for anyone else to want to touch. It took several months before anyone at that clinic responded with more than a form letter acknowledging receipt of the inquiry. The person who finally did was a second-year law student named Michael Ruiz, working under a supervising attorney who ran the clinic's small innocence project, and the case file he was eventually handed, almost as an afterthought between 2 more urgent matters on his desk, was Sarah Mitchell's. Michael was not looking for a career-defining case when he first opened that file late one evening after his own classes had ended. He was looking, if he is honest about it now, for something manageable enough to fit around an already demanding course load, something he could review in an evening and return with a polite explanation of why the clinic couldn't take it on. What he found instead, buried in a case that had been closed and largely forgotten by nearly everyone except the family still living inside its consequences, was a set of small, nagging inconsistencies that no one along the way had ever bothered to chase down properly. A witness statement from a neighbor that had never been followed up after the initial police visit. A timeline in the original police report that placed Dale's arrival home nearly 40 minutes later than Sarah's own statement claimed, a gap nobody had ever explained. And a single line, easy to miss on a first read, noting that the responding officers had briefly interviewed a young child at the scene that night, an interview that existed nowhere in the trial record at all, as though it had simply been misplaced somewhere between the night of the arrest and the 4 days of trial that followed months later. Michael brought the file to his supervising attorney the following morning, a woman named Patricia Alvarez, who had spent almost 15 years working wrongful conviction cases before she ever set foot inside a university clinic. Cases she had taken on in courtrooms across 3 different states before deciding to spend the second half of her career training the next generation of attorneys who might carry that same work forward. Patricia had seen enough files over the years to recognize the particular shape of a case that had been rushed, under-resourced, and quietly mishandled by nearly everyone involved. Not necessarily out of malice, but out of the ordinary, exhausting momentum of an overloaded system that moves faster than it should and asks far fewer questions than it actually needs to. Patricia agreed to take the case on, but only on one condition. She wanted to talk to Grace herself, now 9 years old, and she wanted to hear, in Grace's own words, without any adult filling in the gaps for her, what she actually remembered from a night that had happened 2 years earlier, a night nobody in a courtroom had ever once asked her to describe out loud. Michael arranged the meeting through Grace's grandmother, and on a Tuesday afternoon in early spring, Patricia Alvarez sat down at the same kitchen table where Grace had spent so many nights copying details into a hidden notebook, and asked her, gently but directly, to simply tell her everything she remembered from that night. That conversation would end up being the single most important interview of the entire case, though almost nobody involved fully understood it at the time. Grace, 9 years old and carefully composed in a way that unsettled Patricia more than tears would have, described the night in precise, unhurried detail, her feet not quite reaching the floor from the kitchen chair, her hands folded neatly in her lap the entire time she spoke. She described her mother's voice through the wall, sharp and unafraid, ordering Dale away from her before Grace had even fully woken from sleep. She described the sound of the phone call her mother made from the kitchen minutes later, a call Grace had listened to from the hallway, and the specific words her mother used, words that made unmistakably clear she was calling to get Dale removed from the house, not to quietly explain away something she had simply allowed to happen. Patricia would later say it was, without question, the account of a woman actively trying to stop the harm in real time, not a woman who had failed to notice it or chosen to ignore it. What struck her most, she has said in the years since, was not simply what Grace remembered, but how consistently she remembered it. The same details, the same sequence, the same specific words, appearing identically each time Patricia gently asked her to repeat parts of the story over the following weeks. Children's memories are often dismissed in courtrooms as unreliable by nature, shaped too easily by suggestion or the passage of time, but Grace's account never wavered, never grew more dramatic or more convenient with repetition, a consistency that would eventually become one of the most persuasive elements of the entire appeal. Patricia and Michael spent the following months building what would eventually become the formal appeal, working faster than either of them was entirely comfortable with, because every single week that passed was another week Sarah spent behind bars for something the case file itself was increasingly arguing against. They tracked down the neighbor whose original statement had gone unfollowed, a woman who confirmed, somewhat reluctantly at first, that she had heard raised voices from the Mitchell house that night, and something that sounded like Sarah defending her daughter, testimony that had simply never made its way into the original trial record at all. They located the responding officer who had briefly interviewed young Grace at the scene, a man who still remembered the interview clearly enough to confirm it had happened exactly as the case file suggested. That officer, when finally located and asked directly, admitted, somewhat uncomfortably, that he had no real explanation for why his brief conversation with Grace had never been logged as part of the formal case file submitted for trial. It was, he said, simply an oversight. One interview among dozens conducted that chaotic night, filed away, or perhaps never filed at all, in the confusion of processing an arrest, securing a scene, and managing a frightened family, all within the same overwhelming hour. It was an explanation that satisfied no one, least of all Patricia Alvarez, who understood immediately that this single oversight, however unintentional, had quietly cost a 7-year-old girl the chance to be heard at the exact moment her voice might have mattered most. Patricia and Michael also brought in, for the first time in the entire history of the case, an expert witness on coercive control and intimate partner violence, testimony that had never once been presented at Sarah's original trial 4 years earlier. This expert, a clinical psychologist who had spent over a decade studying patterns of abuse and the behavior of victims trapped inside them, would eventually explain to the appeals court something that domestic violence advocates had been trying to get courts across the country to properly understand for years, that a woman in Sarah's position, isolated, financially dependent, and afraid, often does not experience her own situation with the clarity a courtroom later expects of her when reconstructing events after the fact. She does not always leave immediately, the expert explained, even when the danger is real and escalating. She does not always report every incident, even when she understands, on some level, that she probably should. She often stays, hoping quietly to manage the danger from the inside, to keep the peace just long enough to protect her child without triggering something worse. right up until the exact moment she finally cannot manage it any longer, and it was in that precise moment, the expert would testify under careful questioning from Patricia, that Sarah had picked up the phone herself and called for help, an act the original trial had somehow transformed into evidence of failure rather than evidence of exactly the opposite. By the time the appeal was finally scheduled to be heard, just over 2 years after the sentencing that had torn her family apart, Grace was 10 years old, still small enough that the courthouse chairs seemed built for someone twice her size, but old enough by then to have spent nearly a third of her entire life carrying the details of this case, the way other children carry a favorite book, memorized, worn soft at the edges from repetition, returned to again and again whenever she needed to steady herself. Patricia had, by then, come to trust Grace's understanding of the case more completely than that of almost anyone else on the legal team, not because Grace held any formal training, but because she was the only person in that courtroom who had actually lived inside the night in question. The morning of the hearing arrived cold and overcast, the kind of gray Oklahoma morning that makes everything feel slightly heavier than it otherwise would. Sarah Mitchell was brought into the courthouse from the correctional facility, where she had spent a little over 2 years of her life, dressed in the plain state-issued clothing that had already become, in some strange and terrible way, more familiar to her than she wanted to admit to anyone, including herself. She had not seen Grace in person in almost 4 months. Communication between them limited mostly to letters and rare, heavily monitored phone calls scheduled around the facility's own restrictive routines. When she was finally led into the courtroom and saw her daughter seated beside Patricia Alvarez at the counsel table, hands folded carefully in her lap exactly the way her grandmother had shown her, Sarah would later say it was the first moment since her sentencing that she allowed herself to genuinely believe something might actually change. The hearing opened with Patricia Alvarez laying out the full procedural grounds for the appeal, methodically working through the missing witness statement, the unlogged interview with young Grace at the scene, and the complete absence of any expert testimony on coercive control at the original trial. It was careful, deliberate, exactly the kind of argument appeals courts expect, and more often than anyone likes to admit publicly, quietly deny anyway. The judge presiding that day, a measured woman named Eleanor Vance, who had sat on that particular bench for nearly 20 years, listened without much visible reaction, the same careful, unreadable expression she reportedly wore through nearly every hearing that crossed her desk, regardless of how the case eventually turned out. Nothing about the first hour of that hearing suggested it would end any differently than the dozens of similar appeals that had come before it in that same courtroom, each one built on solid legal ground, and each one, more often than not, quietly denied anyway, once the written ruling finally arrived weeks later. The prosecution, represented that day by a younger attorney who had inherited the case file from someone else entirely and had not been personally involved in the original trial, offered a measured response, arguing that the original trial had followed standard procedure and that any gaps in the record, while regrettable, did not rise to the level required to overturn a jury's considered verdict. It was near the end of the hearing, after the formal arguments had been made on both sides and the prosecution had offered its response, that Patricia turned to the judge and asked for something unusual, permission to have Grace Mitchell address the court directly, not as an attorney, since she was of course only 10 years old, but as the only living witness to the actual events of that night, present now and willing to answer any question the court might have for her. It was an unusual enough request that for a moment it seemed the judge might simply decline it as unnecessary, given how much was already sitting on the record in front of her. But Judge Vance, after a long pause that Patricia would later describe as the longest 30 seconds of her entire career, agreed to allow it, on the condition that the prosecution be given the opportunity to question Grace as well. Patricia accepted that condition without a moment of hesitation, because she had spent months quietly preparing Grace for exactly this possibility, not by scripting anything for her to say, but by simply helping her practice describing what she remembered clearly, calmly, and in her own words, whenever anyone happened to ask. Grace rose from her seat at the counsel table, not the witness stand, a small but deliberate distinction Patricia had specifically fought for in the days leading up to the hearing, and walked to stand where she could look directly at the bench, a 10-year-old in a borrowed cardigan, standing in the exact spot where grown attorneys usually stood to make their final arguments. She did not read from any notes. She described, in the same precise and unhurried way she had first described it to Patricia at her grandmother's kitchen table, the sound of her mother's voice through the wall that night, sharp and certain, ordering Dale away from her before either of them fully understood what was happening in that moment. She described listening from the hallway as her mother made the call for help herself, repeating the specific words her mother had used, words that made unmistakably clear she was trying to end the danger in that house, not conceal it from anyone. The courtroom, according to everyone present that day, had gone almost completely silent by the time she finished. The kind of silence that settles over a room when everyone in it senses, without yet knowing why, that something important is about to happen. And then, in a moment, nobody in that courtroom, not even Patricia, had fully anticipated or rehearsed. Grace turned toward the prosecutor's table and asked a single question of her own, a question that had waited 2 years to be spoken out loud in a room finally built to hear exactly this kind of thing. She asked why, if the state believed a 7-year-old's memory was too unreliable to be trusted at trial, that same 7-year-old's brief and never-logged statement to police on the night of the incident had been quietly left out of the case entirely, rather than simply presented to a jury and weighed for whatever it happened to be worth, alongside everything else the jury had been asked to consider. It was not a legal technicality dressed up as a dramatic line for effect. It was the exact question sitting at the center of everything that had gone wrong in that original trial, the question that exposed, in a single sentence spoken by the very child at the heart of it, how a child's voice had been treated as simultaneously too unreliable to include and too inconvenient to lose entirely, two contradictory justifications that could not both be true at once, and that no one on the prosecution side had ever actually been asked to reconcile until that exact moment, asked now by the same little girl, 3 years older, still small enough to need a step stool to see over the counsel table properly. The prosecutor, caught genuinely off guard, struggled visibly to answer, offering a fragmented explanation about the general standards courts apply to child witness testimony, an explanation that trailed off before it ever fully resolved into anything coherent enough to satisfy the room. Judge Vance did not interrupt him as he stumbled through it, but she did not need to. The silence that followed his unfinished answer said more than any ruling could have said in that particular moment. Patricia would later describe watching the judge's expression shift, subtly but unmistakably, from the practiced neutrality she had maintained through nearly every hearing of her long career into something closer to genuine reconsideration, the specific look of a person quietly recalculating a decision they had believed, only moments earlier, they had essentially already made. Judge Vance did not rule from the bench that day, which surprised almost no one familiar with how appeals of this kind typically unfold. Everyone in that courtroom understood they would likely be waiting several weeks for a formal written decision, the standard timeline for a ruling this complex. But something had unmistakably shifted in that room, and everyone present could feel it, from Patricia Alvarez, who had personally watched hundreds of appeals hearings end without any visible change in a judge's demeanor, to the correctional officers standing quietly near Sarah, who exchanged a brief, uncertain glance with one another as the hearing was finally adjourned for the day. Sarah was returned to the facility that afternoon, not knowing whether her daughter had just witnessed the beginning of her release, or simply one more procedural step in a system that had already taken over 2 years of her life without ever fully explaining why it needed to. The written ruling arrived 7 weeks later, delivered first to Patricia Alvarez's office by courier and then, by phone within the hour, to Sarah herself at the facility. Judge Vance's opinion ran to nearly 40 pages, methodical and unhurried in the way appellate rulings typically are, working carefully through every argument raised at the hearing before finally reaching its conclusion. That conclusion, when it came, was unambiguous. The court found that the original trial had failed to adequately consider available evidence, including the unlogged interview with young Grace Mitchell and the complete absence of any expert testimony on coercive control, and it formally vacated Sarah's conviction, ordering either a new trial or her immediate release pending further review by the district attorney's office. Given the more than 2 years Sarah had already served of a 15-year sentence, and given a case record that no longer looked, in the light of everything now sitting on file, like one the state had much genuine appetite to retry from the beginning, the district attorney's office ultimately chose not to pursue a new trial at all. Sarah Mitchell walked out of the correctional facility on a gray Tuesday morning in early November, 2 years and 7 months after she had been led out of that same small county courthouse through a side door, with her daughter reaching for a hand she could no longer hold. Grace was waiting for her in the parking lot that morning, 10 years old, wearing the same borrowed cardigan she had worn to the hearing weeks earlier, standing beside her grandmother's car with both hands pressed flat against the cold metal of the hood because she couldn't quite make herself stand still. Neither of them said very much in that first minute together. Sarah would later describe it as the strangest kind of silence she had ever experienced in her entire life. Not empty, but too full to hold any single sentence. More than 2.5 years of everything neither of them had been able to say to each other, finally standing quietly in the space between them, waiting for one of them to be ready to speak first. It was Grace, in the end, who moved first, closing the distance between them without a word, and the two of them stood together in that parking lot for a long moment while her grandmother waited quietly by the car, giving them exactly as much time as they needed before anyone said anything at all. In the months that followed, Sarah slowly rebuilt a life that had been interrupted rather than ended, finding steady work again at a different diner across town, learning to navigate a community that had watched her leave in handcuffs and now had to decide, in its own quiet way, how it wanted to watch her come home. Some neighbors offered exactly the kind of quiet, ordinary kindness she remembered from before. Casseroles left on the porch. An old coworker who simply hugged her without saying anything at all. Others kept their distance, uncertain how to reconcile the version of Sarah described in a newspaper years earlier with the woman now living 2 streets over. And Sarah has said she understood that hesitation more than she resented it, because she remembered how uncertain she herself had once been about people whose stories she had only ever read secondhand. The 15 years the original sentence had promised never came to pass, and both Sarah and Grace understood, in the particular way people do after something like this, that the difference between those 15 years and the 2.5 Sarah actually served had come down, in the end, to a single afternoon, a single hearing, and a single 10-year-old who had simply refused to let her mother's case stay closed once every adult around her had already quietly decided it was finished. In the years since, the case has become something else entirely in local legal circles, cited occasionally in law review discussions about coercive control, about missing evidence, and about the particular danger of treating a child's memory as useful only when it happens to be convenient for the state's case, rather than the truth of what actually occurred. Michael Ruiz went on to finish law school, and now works full-time at the same clinic where he first opened Sarah's forgotten file, taking on cases that remind him, he has said, of exactly why he chose this work in the first place. Patricia Alvarez continues to train the next generation of students who pass through that same small program, and she has said publicly, more than once, that Sarah Mitchell's case remains one of the clearest examples she has ever encountered of how quickly a justice system can fail someone, not through any single dramatic act of malice, but through a long accumulation of small oversights, each one reasonable enough on its own, that together add up to 15 years taken from a woman who was, the entire time, trying to do exactly the right thing. Grace grew up in the years that followed in the shadow of that hearing, rather than the shadow of her mother's absence. And she has said, in the rare interviews she has given as she has gotten older, that she never really thought of herself as her mother's lawyer, because she was only 10 years old that day and had never studied a single page of actual law. What she was, in the truest and most literal sense, was the only surviving witness the state had ever failed to properly hear, a child whose account had been quietly excluded from a trial that decided the next 15 years of her mother's life without ever once asking her a single question about what she actually remembered from that night. It took 2.5 years, 3 attorneys working largely without pay, one exhausted small-town legal system stretched far too thin, and a single unanswered question finally spoken out loud in the right room, at the right moment, in front of the right judge, to correct a mistake that had been sitting quietly in a case file the entire time, waiting patiently for someone invested enough and stubborn enough to finally go looking for it properly. Sarah Mitchell has said, in the years since her release, that she has made a kind of peace with the time she cannot get back, though she is careful, whenever she talks about it publicly, never to describe that peace as forgiveness, because she does not believe the system that took those years from her has ever fully earned that particular word. What she says instead, whenever people ask her how she managed to survive those 2.5 years, is simpler than that. She says she always believed her daughter remembered the truth of that night, clearly and completely, even when nobody in a position of real power was willing to ask her what that truth actually was. And she says that belief, held quietly and without any guarantee it would ever matter to anyone beyond their own small family, turned out to be the one thing in that entire case that never once needed correcting, from the very first night to the very last hearing. If a story like this one makes you think differently about how the justice system treats the very people it claims to protect, and about how easily a child's voice can be left out of a room built specifically to decide that child's own future, let us know your thoughts in the comments below. And if you want to see more real stories like this one, stories about the cases the system almost got wrong before someone finally refused to let them stay that way, consider subscribing so you never miss one.